house on fire. Boy, oh boy, this is something else. Let me bring in my guest, get his thoughts on this. Criminal defense attorney, former prosecutor, our friend John Mobley on the show. John, I can't believe what I'm hearing. My goodness, this is not good for Karen Read if the jury sees this, and you know it's an admission. The admission itself is coming in. The question here is whether they can show her in custody. Talk to me about your thoughts on this and what ultimately the judge is going to do.
I tell you, Julie, I'm reasonably certain these statements will be admitted to the jury. I mean, I certainly don't blame her lawyer for trying to keep them excluded, but they were made voluntarily. I mean, as the prosecutor indicated, she was advised of Miranda rights. She was told to be quiet. She couldn't keep her mouth shut. I think it's very easy to keep out evidence that the defendant was in custody. You know, you just don't use the video. You have the witnesses testify that they were talking to her as part of the investigation, and these are the statements that she made. Now, of course, if the defendant opened the door to things that require use of the video, I think that's always a risk. But I just think that's just something to deal with. These defendants, they make these statements throughout the course of the case, and they come back to bite us. He's kind of stuck with that.
Isn't that the truth, John? And I like what you said there. You wonder if the judge may do something like just isolate the audio, let everybody hear her words, hear her voice, let the troopers talk about it, and say for reasons of fairness, we can't show the video, but there is video. Whoa, this is really bad for Karen Read. My goodness, more